My name is Jeremy Janis. I'm a partner at LOIS Law Firm. Before we get started, we're just going to get through the housekeeping. This presentation is instructional and not for legal advice as to any particular matter. There's no attorney-client relationship. LOIS Law Firm is a continuing legal education accredited provider by the New York Continuing Legal Education Board to offer accredited courses. This is a live classroom course today. It's offered free of charge for 1 credit. It will give you a 1 credit for experienced attorney professional practice requirement. To comply with the CLE provider requirements, it may be recorded. You should have received handout materials at home if you didn't already. And if you didn't, just let us know now and we'll get them to you. You cannot get the CLE credits unless you've received the accompanying materials. Please put away any device that buzzes, makes noise, or will otherwise distract you. Attendees, both online and here, are encouraged to ask questions of the presenter to clarify concepts or legal strategies discussed or otherwise pertain to the subject matter of instruction. And attendance for those that are attending remotely will be verified electronically. And the people that are here, just make sure you sign in and sign out. After the presentation, you'll receive a questionnaire. Just fill it out and give your feedback. And you will get your CLE credit or certificate of attendance after the presentation ends. Today, we're going to cover a number of topics. We're going to start by discussing maximum medical improvement. We're going to get into scheduled loss of use, how to use the disability duration guidelines to find degree of impairment and scheduled loss of use cases, and then our best practices on presenting guidance on exposure and settlement and scheduled loss of use cases by using litigation risk and discounting and scheduled loss of use. Today, we're going to take a little bit of a different focus than we usually take. In addition to the background information, we're going to talk a little bit more about apportionment or ways to reduce exposure. And we're going to give a recent case law example. And then we're going to talk about inconsistent range of motion, poor effort, inconsistency with treating records, and a case law example as well. Essentially, just putting a close eye to medical records, looking at the medical history as an overall picture and trying to see, like, did the claimant give a full effort at the permanency evaluation as opposed to when he treated throughout the life of the claim? So we'll get into that a little more as we go along. But we're looking for ways to reduce exposure on these scheduled loss of use claims. All right, maximum medical improvement. The guidelines state that when impairment is determined for most body parts, it is 1 year from the injury or last date of treatment, commonly referred to as MMI. You guys know this pretty well by now. The claimant has recovered from the work injury to the greatest extent that is expected. No further improvement is reasonably expected, and the need for palliative or symptomatic treatment does not preclude a finding of MMI. And it cannot be determined prior to 6 months from the date of injury disablement unless agreed to by the parties. So generally, unless the parties reach a stipulation and agree that the claimant has reached MMI prior to that date, you're not going to get that finding. And any IME report that states otherwise is probably going to be found incredible. According to the workers' compensation guidelines, MMI finding is based on the medical judgment that the claimant has recovered from the work injury to the greatest extent that is expected. No further improvement or in his or her condition is really expected. So essentially, they've reached the plateau for the treatment that they received, and they're not going to get any better. They're not back to fully where they were, but they're not going to get any better than they are right now. Claimant tries to delay an MMI finding one of 2 ways. The first that we see a lot is waiting to get a surgery until we get that IME report. And they said, oh yeah, remember that surgery I didn't get? I'm gonna go get it now. Try to push off an MMI finding. They want to increase the weeks, which we'll get into at the temp total rate. They also want to push off. They just want to continue to be out of work and get awards. But when we see that happen, we got to remember the claimant must not only qualify for the surgery, but also have specific plans for surgery, including an active request for pre-authorization if required. So we should be, if there's no request in there, that should not bar a finding of MMI. The other thing we see even more often is the raising of additional sites. Claimants love to start over when they have reached MMI. Beware of this tactic. Challenge additional sites by taking the testimony of the treating physician and presenting contradictory medical. I also like to ask for mechanism of injury testimony if the claimant is alleging an additional site that was directly related to the date of loss. I want to request the incident report, internal incident report from the employer. Did he report that injury at the time of the injury? At the time it was reported, number one. I want to talk to a witness, and I also want to take the testimony of the claimant, put him to the proofs. And can you raise Section 28? Is it over 2 years after? Was it any other medical other than now? Make it as hard for them as possible. We want to push the MMI finding, and we don't want to increase the exposure by these additional sites. Most of the time are BS being raised later on in the claim. This is just an example of C4.3. All you guys know this already. It's the form that used by both the IME doctor and the treating doctor to determine or show whether the claimant has reached MMI and show the findings that they relied upon when making a determination regarding the claimant's permanent disability. So now we're going to specifically get into schedule loss of use. Schedule loss of use, as you know, does not compensate the claimant or an injured worker for pain and suffering, and it does not represent damages for loss of a finger, foot, or any other member, but instead the award is to compensate for the loss of earning power. And essentially, as we know, it's independent of however much lost time the claimant has. So the claimant can be out of work for 0 days, work full duty the whole time, and still receive a significant schedule loss of use. If his range of motion is really bad or he qualifies for a specific special consideration. And ultimately, the schedule loss of use is a legal determination made by the board based on the medical evidence of residual physical and functional impairment, considering in consonance with the impairment guidelines, as well as other evidence relevant to the claimant's prospective loss of earning power. Schedule loss of use, as we know, applies to essentially all the extremities, arms, hands, fingers, legs, feet, toes, eyesight, hearing, and disfigurement, and sound, specifically in section WCL section 15.3. Each one of the body parts has an enumerated number of weeks for which it's worth, and this just enumerates what 100% schedule loss use would be for each one of the body parts, with the arm being worth the most, 312 weeks, the leg, the hand being worth a little bit less, and then so on down to the small toe, which is worth only 16 weeks. The process for MMI is that both sides, one party usually gets a report that says the claimant's at MMI, or we kind of raise the issue and be like, MMI is right. Both sides get their own impairment ratings that comment on permanency. We take medical testimony if the two sides differ, and then the judge determines what the schedule loss of use award is in a ruling. We talked about this before, and I know we talked about it at the last presentation, that claimants are incentivized to take as much time as possible to heal. It's the only, I guess, area of medicine where you see the claimants actually want to take more time to heal as opposed to less time to heal. Most people want to get better, but there is a statutory construction that was created by the Workers' Compensation Board about 100 years ago called protracted healing period that actually motivates them to have more weeks at the temporary total rate, which essentially states that each body part has a normal healing period. So it should take a normal amount of time to heal. And if it takes longer than that, the claimant should be or will be entitled to an additional award. So for the arm, that's 32 weeks, the legs, 40 weeks. So the claimant's out of work at the temp total rate for, let's say, 60 weeks, and the claimant has a leg injury, he's going to get 20 additional weeks on top of the schedule loss of use award. So it really does incentivize the claimant to stay out of work at the temporary total rate. It also should incentivize us to request depositions as early as possible and get IMEs as early as possible, because we need to make sure they don't get these protracted healing periods awards. And this is just an example of a PHP award, and it just shows that you calculate the schedule loss of use, add the PHP on top of it, and you get a gross award. There's ways. So these are ways for the claimant to increase their award. There are ways. So one of the focuses we want to have today is apportionment. Apportionment allows us to send the exposure to some other claim or reduce our exposure because the claimant had some other injury that had contributed to this specific injury. So we're going to talk about a few different types of apportionment. The first is pursuant to matter in judicio, and that's where the claimant had a prior schedule loss or prior workers' compensation claim that resulted in a schedule loss of use for the same body part. Generally, and before recent cases, it was the claimant had an injury to the same body part. It would be simple subtraction. The claimant had a 20% schedule loss use in the past and has a 45% schedule loss use now. You would just subtract it. But there's been case law recently, specifically, and we'll get to it after this, that provides a little bit of an exception to that. So first we're going to talk about a pivotal case called Scally, which allows us to portion something to a non-work related injury if the injury would have resulted in a schedule loss of use if that accident had taken place in a work environment. So the standard there is we have to prove to the board that had that injury taken place at work, the claimant would have been entitled to a schedule loss of use award. It's a very specific framework, but it's a framework nonetheless that allows us to apportion something to a non-work related injury. Okay, so we'll get to how that affects us in general, but we should know that we don't have to prove other things. So we do not have to show that there was an actual diminution in earnings or working ability, just that the medical evidence of a pre-existing loss of use, range of motion, or function of the body part in question would have resulted in a scheduled loss of use had the prior injury been compensable. So to me, it's as simple as looking, did the claimant have a prior injury? Did it result in some kind of diminution in range of motion? If it is, it's worth a try. So how do we do that? First of all, we got to ask for the ISO, right? We got to get the prior records. Number two, and the third thing is we ask the doctor, right? I don't know. We draft tons of IME cover letters. Would you have found a scheduled loss of use award following the prior condition had the prior injury been work related? Simple of a question as that, because that is the standard that the board's going to look at. So when they answer yes, you're already set up to get that question answered by the board. Yes, he's stating that. And then you have to ask both the treating and IME doctors, would you have found a scheduled loss of use award following whatever happened had the prior injury been work related? So when we do know that information, it's more likely than not that, in most cases that I've seen, that the other doctors might not know about that injury and they might not have those records. So if we get that opinion and we frame it in that way, we already have a leg up. We know what the standard is, and we can use that to our advantage. So I know we haven't thought about the matter of Scally that much, but we should be thinking about it. So I'm going to go back to matter of judicio a little bit. Matter of judicio, as I said, it used to be a simple subtraction. But now this case law, matter of Johnson and matter of Leaning came along and said, if the claimant can prove that the second injury or the newer injury is not in conjunction with the old one, then they get into the entirety of the scheduled loss of use award for the new injury. So what that means is essentially the claimant's doctor has to state that the new injury is separate and distinct from the old one. So it doesn't matter that he had the prior injury. This injury had nothing to do with that. And as a result, I should get the entirety of the scheduled loss of use award. And in that case, the scheduled loss of use would stack, but I would remember, we talk about burdens, and the burden is on the claimant on this side to prove that. So I would put the claimant to the proofs, put his doctor to the proofs. Do they even know about the prior injury? Sometimes they don't. Does our IME doctor, we want to make sure our IME doctor knows about it, right? When they make their determination, because then we have a leg up again. We can use the information that we have to gain an advantage over the claimant. Before we get to how to calculate schedule loss use, there is another type of apportionment that's not in the slides that I just would be amiss to not talk about, which is Section 44 apportionment. And Section 44 apportionment occurs in the case of an occupational or repetitive use claim where the claimant worked in the same type of employment for a number of years and had different positions. So let's say the claimant was a construction worker and he worked for us specifically for a month, but he also worked in that same employment doing the same exact job for other employers for 40 years. What the case law says is that the last injurious exposure or the last employer will likely be stuck with paying the awards, both the indemnity and the medical. But when the time of permanency comes, we can go back after everybody else and try to recover pursuant to how long the claimant worked for each one of the employers. So even though we may have to pay everything out at the start of the claim, as the claim goes on, we might get 95% of that back or 99.5% of that back at the time of permanency. So for our purposes, it's why it's important that when we first get a file, we get a resume. We want to see the claimant's work history. If the claimant was a union member, we want to get the union records. We want to be prepared for the time when the claimant does reach permanency. We can go after all the employers, bring them in. And these hearings can become big circuses because sometimes there might be 30 prior employers and everybody's trying to figure out what portion there is. But like we want to know, number one, if we know that at the start of the claim, you can prepare the employer, let them know, like, listen, hey, I know you're gonna have to pay all this money out if the claim is established, but there's a good chance you can get 90% of this back, right? It will affect how you handle the rest of the claim. So that's just another very powerful way to get a lot of money back and reduce our exposure significantly. Okay, so schedule loss use. Most of you guys have done this already. 25 schedule loss percent equals 72 weeks. 700, take the temp total rate times the number of weeks. With apportionment, done slightly differently. We portion 40% to the prior claim, so we subtract it from 100% and multiply it by the total award, and that's how we get the award. Just remember that temp total rates are changing actually in less than a month, as are the temporary minimum rates are changing as of July 1st now every year, pursuant to the percentage of the state average weekly wage. So we're gonna have a jump of about $60 in about a month for the statutory minimum and a jump of about $60 for the statutory maximum as well for any dates of loss after July 1st, 2026. And it's just important to remember that because, as you know, schedule loss of use goes by temp total rate. So it's just important that we remember the proper temp total rate. Now we're going to talk about the disability duration guidelines, how they're organized, how impairment is determined, and how special considerations are applied, and what doctors are supposed to do. Doctors determine impairment, which is a purely medical determination made by a medical professional, defined as any anatomical or functional abnormality or loss, requires a complete medical examination and accurate objective assessment, and considered permanent when MMI has been reached and there is a remaining impairment. Judges determine disability. This is a legal determination, and they do that based on the medical evidence and other relevant information. Sections chapters 2 through 9 of the 2018 impairment guidelines pretty much break down normal range of motion for all the body parts, how the doctor is supposed to perform the examination, what methods they're supposed to use, how special considerations are applied, and how to deal with amputations. When doctors are evaluating the level of impairment, the contralateral side should be considered for comparison for expected normal values when appropriate. Only if the contralateral limb cannot be examined should the normal values be used. Look to the objective findings of the physical examination and data contained in the patient's medical record, not the severity of the injury. And as you know, you must use a goniometer, active range of motion 3 times. So all those things are requirements. They're not like recommendations. So these are questions we should be asking the doctors each and every time. And when we're reviewing reports and trying to figure out how credible they are, we should be looking at each one of these requirements and seeing if the doctor did it and making our analysis based on that. Simply restated, yeah, we must look at the contralateral member if appropriate. What is appropriate? Usually when the contralateral extremity is not injured. And this is an important opportunity for cross-examination. You find a lot of treating doctors forget to do that part, or they forget to record 3 range of motion deficits for the contralateral member. You're not doing it correctly then. And the doctor is expected to apply special considerations for some body parts and conditions. And the instructions have clarified whether a condition that falls under special consideration is evaluated as a standalone or value that is added to a range of motion findings. The case law out there has changed. It used to be you could not, before matter of blue, and I don't know if any of you guys remember this, for something like chronomalacia patella, you used to be able to just say 7.5 to 10% and not add any range of motion deficits. Now the case law says something slightly different. If chronomalacia patella is present, and let's say there's a meniscal tear as well, and that was the basis for the range of motion deficit, then you can add the two together now. So essentially what it says is, yeah, the special consideration of present, but if there's any finding that's present other than that, that could contribute to a range of motion deficit, then you have to add that on top of it. Now, there's other special considerations that specifically work in range of motion deficits and talk about it. Some of them might say use the single most extreme deficit and add it on top of it. So you just have to make sure you differentiate it and read the special considerations very carefully. They will explicitly state when you're supposed to add it on or consider it as part of the special consideration. But the thing we should be remembering is if there's just chronomalacia patella present, we should be arguing that there should be no additional, or there's just, something else that's present. We only find that there's one finding in an MRI. We should be arguing that simply it should just be the special consideration. Okay, again, this is just repeating that range of motion 3 times, find maximum, use a goniometer. Doctors sometimes use the average, call them out on it. And make sure our IME doctor is not using the average, because sometimes they do that as well. And if they are, let our client know that our report is not that great. And essentially, it's just a protractor that measures range of motion. Okay, our best practices are always check the findings of the evaluating physician to make sure they support the impairment percentage. Was the contralateral limb measurements taken and used? Did the claimant have worse findings in the C4.3 permanency exam than they did during treatment? For example, did they have better range of motion and physical therapy notes? So there was a recent case, Midwest Steel. It's a board panel decision that came out within the last 2 weeks, where the board looked at the claimant's efforts and determined that they did not give their best efforts by looking backwards at prior medical records and noting that range of motion was significantly better at prior examinations. And they said, no, they said the judge can then make a credibility determination based on that and find that that report is not credible, or that doctor's report is not credible. To take that a step further, there is about a year and a half ago, there was a case called Matter of Motto that came out. I know some of you guys know this case. There used to be a case called Docs Kakasaki, which was, I believe, a full board decision that came out about 7 or 8 years ago that used to state that if the claimant has significantly worse range of motion at the permanency evaluation, then we can rely on an old report and implement the claimant's, schedule loss of use based on an old report. This Matter of Motto said, okay, we understand that the claimant sometimes has worse range of motion and may be voluntarily restricting at the permanency evaluation. However, in order to make a schedule loss of use determination, we do need an examination. We do need the schedule loss of use to be based on some kind of examination. So what the court did in that case was, instead of implementing a prior report, they decided both reports are incredible, and they directed both sides to actually get new permanency reports stating that there was no credible evidence of permanency. So if we look at both reports and be like, wait, this guy had 0 to 160 the whole time, and then he goes to the permanency evaluation, his range of motion is like, he can only go up to here for his shoulder. Something's wrong, right? So we should either be thinking about Midwest Steel, which is this recent case, or Matter of Motto, and try to get both reports kicked. But I would be raising fraud as well and be like, claimant shouldn't get anything. He's definitely magnifying of symptoms. I would also recommend surveillance at that point. Because more likely than not, a lot of these guys are working, number one, so we should have already recommended surveillance at work, him performing his job duties, or he's out and about and going to the store and able to have full range of motion, but going to these examinations and barely able to reach above 90 degrees. Just doesn't make sense. So remember, again, we want to use our leverage, even though the burden is on us to raise apportionment improvement. Simply raising it may create enough leverage towards more favorable settlement. And then where the claimant has demonstrated inconsistent effort during scheduled loss of use examinations and contrasted with prior treatment records, use this as leverage to obtain a more favorable settlement. So again, just look at the file as a whole. Make sure we see the whole picture and not just the permanency evaluation. Just want to make sure, again, this is just showing how to calculate slew exposure and making sure we take credit for prior awards and add money if there is a protracted healing period. The evaluating and treating physicians will often disagree on the nature and extent of impairment. It is common for the physicians to disagree on the extent of impairment, with the treating physicians typically finding more disability than examining physicians, and it is less common for the physician's C4.3 reports to disagree on the body parts affected. Most common injuries have a narrow range of impairment findings. Doctors rarely agree, and we should be reviewing the report compared to prior treatment records, and we should try to figure out how the physician testifies when we make a settlement recommendation. And in addition to our internal records that we have, where we have deposition transcripts available, I like to look at board panel decisions sometimes to see how doctors testify and how their scheduled loss use opinions hold up, just to see, like, okay, what did the board look at these times to like discredit? It doesn't hurt to find these doctors and like say, okay, you found them incredible in this case, and this case for this reason. Did the same thing here. You got to agree with us. So when we are discounting settlements, we're trying to determine like how to recommend what the exposure is. At this time, we should consider litigation risk to both sides. What are the costs and likely outcome? Do we have covert information that impacts credibility? Do we have surveillance that we know just contradicts 100% what the claimant exhibited or stated at the IME, right? That has a direct impact on what we should be recommending. And when the claimant just has a ridiculous scheduled loss use case and it's not an amputated member, we should be requesting depots, because what do we have to lose? We should consider right now money to the claimant. We should be looking into things like, where is the claimant living? Are they living with their kids because of this? Are they moving? Is there some reason they want the money right now? We might be able to get a better deal. We use ATF tables to discount present value, and we should consider indemnity only where future medical is likely to be minimal or unlikely. And that just gets rid of any risk of additional indemnity exposure. When we're discounting, we use Board Bulletin Section 222C. And as defense counsel, just remember we recommend the amount of settlement authority that our client should extend to us. We ask for dollars, not percentages. Just make sure we use the right verbiage, that we make offers, we make counter offers, and we ask or solicit demands. We don't make demands. We don't refer to the claimant's demand as an offer for settlement. We don't tell clients that the claimant offer to settle is. We don't ever recommend paying total loss, 100% scheduled loss use, unless it's actually an amputation. And for fingers, we got to be careful about that, because it's a part of the finger, it's still not 100%. So just make sure you look at the guidelines before that. We also don't want to be a calculator. Our clients can do that themselves. They can figure out how to go on a calculator and figure out what the award is worth. We don't want to provide a broad range without an analysis of the limits of that range. We don't want to give, if we're telling them it's 25 to 75%, we're really telling them nothing. We're just giving a really broad range. We should be telling them, okay, based on what I think in my review of the medical records, we think it'll end up at 20%. Here's why. Just do your best. Do not assume that the client wants to settle. They might have reasons for not wanting to settle. Think about what they want and what their strategy is. And we do not ask for settlement authority in terms of percentage. We could tell them what it's worth, 20%, $300,000, let's say $30,000. We explain how we got there and why we recommend it. Most scheduled loss use cases resolved by way of stipulation or judgment. Again, remember statutory minimum maximum that is about to increase. Don't forget to subtract prior temporary disability payments. And don't rely on Freud or Strois to determine what prior payments are. they're completely and utterly unreliable and most likely wrong. And I don't know about most of you, but it's hard to figure out when the attorney fee's in there, when maybe the employer paid some money, figure out what the actual prior awards are. So ask for payment ledgers. They're the most reliable and probably the only reliable source for prior awards. And then you know that you and the client are on the same page. And when you're giving information to opposing counsel, you know that the information is accurate. So they understand whatever the stipulation is going to be is correct. There's nothing worse than going to the hearing and they're going to be like, oh yeah, we actually paid like $5,000 more, so you're getting less money. And then the opposing counsel gets mad. We should always use form 300.5. And the reason we use that form is because anything that's on that form is reviewable by the Workers' Compensation Board under section 23 and 123. So if you had used, for us, we have a workflow that by default puts our stipulations on that. But if you use something like a conciliation decision, not reviewable, 312.5, this one is. So if the board, for some reason, or as they often do, improperly implements the schedule of loss of use in a PDNOSL, then we can just file an appeal, and it's an appealable issue, and then they can change it. This just talks about all the information we need to complete a stipulation, average weekly wage, temp total rate. I usually like to put what body parts the claimant is established for. The claimant has reached MMI for those body parts. Percentage schedule loss of use equals number of weeks equals the number of dollars. We lay out what the protracted healing period is and the amount of money it's worth. We also, more likely than not, the board has required us to lay out what weeks the claimant has received awards at the temp total rate because they don't want to do that work themselves. And then we calculate the gross to the claimant. We subtract the attorney fee, show what the net to the claimant is. We either lay out the PHP above or we tell the board that there is no protracted healing period. We also want payment. If the claimant chooses to receive their payment in a lump sum, which they do 99.9% of the time, we have to put it in the stipulation because it's something that the claimant has to opt into. Believe it or not. We also just want to reserve our Section 29 rights because we always want to reserve them just in case there's some money out there that we don't know about, and we want to make sure we are letting everybody know and putting them on notice that we are entitled to some of that to recover some of that money. Just remember that a protracted healing period serves to increase schedule loss of use awards when there have been long periods of temporary total disability. It's another reason to challenge payment of temporary total disability benefits. And it's one of the reasons that I use to push back against judges that complain, oh, it's only 3 months into the claim. Why do you want to set it down for depositions? I don't want to review transcripts. Because eventually, if the case gets worse over time, right? At least we can say at the beginning, first of all, we cross-examine the doctor. We know what their concessions are immediately. And number 3, we get them off the temp total rate right away. So whatever happens in the rest of the case, we got ahead of it at least at the beginning, right? And we already know like what concessions, how the doctor examines the claimant, gives us a heads up. And also it serves to get them off the temporary total rate. Specifically, I also recommend that after surgeries, especially like an arthroscopy, some minor surgery that might be, I might recommend it. I know everybody wants to wait 3 months, but I would wait less than, sometimes, depending on what the surgery is, wait less than that. Try to get, because not only do you have to get the IME, right? You have to then request a hearing. So it takes a great deal of time. So the quicker we get them off the temp total rate, the better. Our role is not to just choose the middle of the 2 competing physicians' opinions. It is to advocate for the correct application of the disability duration guidelines and challenge biased reports. And we should be constantly reevaluating exposure of a case as litigation progresses, and especially for schedule loss use cases. Number 1, range of motion is probably always changing. Special considerations might be added as time goes on. Number 2. And number 3, we are constantly, in claims where the claimant has lost time, our prior payments are always increasing. So our schedule loss of use award might actually decrease significantly over time. So we should be letting the client know that. For employers, practical takeaways are that each step in the schedule loss use determination process is an opportunity to create leverage for settlement. Identify the stakeholders early who needs to be a part of the settlement authority process. And that's it. So everybody, please listen to Christian's podcast, Third Friday. It's released on the third Friday of each month. You can either go to our website or go to Apple, anywhere you can download podcasts. Remember to sign out of the presentation and fill out the post-instructional evaluation. And you will be emailed your CLE certificate. For those of you here, please scan the QR code. And then I will take, if anybody has any questions, I'm happy to take them. I don't see any questions online unless anybody has a question here. Okay. You guys are free to go.